Your Honor, normally we would go into the intent part of this, and normally we would ascribe a pretty positive intent to opposing counsel. That's the way that the practice of law works. Your Honor, is because the Commonwealth is very aware that it cannot proceed with a capital prosecution based upon the indictment itself. Facial acceptance of this indictment and its allegations do not give rise to capital prosecution. And that is the failure to render it. And cramming the word intentional in front of it does not save it. It describes wanton murder at best. Now, this purported bill of particulars that was filed about 12 hours ago underscores that. Commonwealth says intentionality as to result of conduct. And that's, of course, inconsistent with the statute. But we're not reaching that question yet. That question, if the court doesn't strike death, will be raised in the future. But what it does show is that the Commonwealth refused to provide any of this information for 6 months because it knew that under this aggravator, that not the conduct needed to be intentional, the killing needed to be intentional. And so a rote recitation of intentionality as to conduct or result fails to save it. We're asking the court to strike death because the Commonwealth has intentionally delayed the provision of this until 12 hours ago, a month past the deadline that was set by the court, because the Commonwealth knows that this is a critical piece of litigation that has to occur in this prosecution. Commonwealth knows that there are things coming up that will impact it, and the Commonwealth chose not to provide that until the eve of court when nobody would have it available. I had to have my team read it to me as I drove here last night. Just the great thing about writing cold chess is that you get what you want right now. And maybe eventually the consequences catch up to you, maybe they don't. But that's exactly what's happening here. Because for 6 months now, the Commonwealth has used the word intentional and has refused to provide any clarification. And then on literally the eve of this hearing, files what it purports to be a bill of particulars, although it fails to actually state the basis for liability and simply recites the statute as to intentionality of conduct. We think that dismissal is appropriate, but if that is too extreme a sanction, we do ask the court to strike death as an aggravator so that the Commonwealth doesn't benefit from its continued refusal to follow the court's orders and continued refusal to make clear this intentionality element. Your Honor, this is a mess, and it has been, and it's only a mess for one reason. And the Commonwealth, rather than responding to the motion for bill of particulars, and rather than providing a bill of particulars, simply looks at the court and says, this court does not have the power to dismiss a case. This court does not have the power to strike an aggravator. But the law is very clear on that. Commonwealth versus Baker makes very clear that this court has that authority. And in the cases that both preceded Baker and came after it, make clear that this court has authority. And this court knows that it is empowered to make these decisions in order to regulate its own work. The court has dealt with discovery violations and issues like this for many years, I presume. And so to sit here and say that the court can issue an order that is not empowered to enforce either through direction or sanction reaches an absurd result. It suggests that the court's opinions
However, we will do that once the court rules upon the totality of the bill of particulars in terms of if the Commonwealth has to answer 1, 3, and 4 as well. He then files the motion in January stating no, that the Commonwealth had already been ordered by this court to provide that, Your Honor, which was not the case. And from my recollection at that hearing that day, the court even pointed out and said, counsel, I'm looking at the order from whatever the date was, and said that's not what it says. It does not order the Commonwealth to respond to those. However, he took it as it does, and he filed that motion to strike the death penalty, to dismiss it based upon that, Your Honor. When we were here last, the Commonwealth again agreed to provide number 2. He states that the Commonwealth said that it would provide it on that same briefing schedule. That may be possible. I'm not saying it's not, Your Honor. Honestly, I don't recall. What I do recall is when I got the order, it said that the Commonwealth has 20 days to file a response to both his motion and the bill of particulars. And that's what the Commonwealth did. The Commonwealth filed a motion or a response to his motion. There's many things he's alleging in this, and he's putting his snark remarks in it regarding different things, Your Honor. He's also following a lab report and misleading the court and the public as to if this child, in fact, was sexually abused.
You're welcome, Michelle. I'm doing the best I can with it.
There's just different things that he's misled this court on, Your Honor. The court Commonwealth has went ahead and filed a response to number 2 of that bill of particulars. That way he has it. I'm sure he's not happy with that response, and I have no doubt there will be future motions forthcoming on that. What's interesting is as he stood up and argued his motion, he said, as to the defective indictment, that other motions will be forthcoming. Ironically, one of the grounds in which gives the court authority to dismiss an indictment is a defective indictment. So, in fact, he knows that if he believes it's an defective indictment, he can file that motion and the court can hear it. And at that time, if the court believes what he said, this court would have that authority, even though the Commonwealth's position is that it's not defective. But based upon what he's arguing in this case, Your Honor, at this time, the court doesn't have authority. Case law says that it does not have authority to dismiss it or to remove the death penalty, because that's solely at the Commonwealth's discretion as to whether it elects that. And then it becomes a question for the jury, Your Honor.
That's fine. Yes. On a few issues, Your Honor, the Commonwealth states that if the aggravating circumstance is present. So I think the Commonwealth understands that the court cannot strike death if an aggravator is present. And that is the goal of this litigation, Your Honor. And that is the goal of a bill of particulars, is to determine if an aggravator is present. Now, the Commonwealth cites to Guernsey for this general proposition that the court can never take death office. Attached a copy of that opinion. I hope that the court will get a chance to review that. The Guernsey litigation, along with Brett Holt and others, dealt with the striking of the death penalty as it related to people under 20. That is the death penalty right in this circumstance? So the trial court did that. And the Supreme Court of Kentucky appropriately held that proportionality review that's there in the statute is properly reserved for the Supreme Court.
It's so Erica Lawson's and Elena Hembree's case.
And it certainly has nothing to do with the court's ability to sanction conduct and to enforce its orders and to make sure that what it's directing to occur actually occurs. The Commonwealth's absolutely correct. We will eventually file a motion to strike this indictment because it is defective. But in order to do so, we have to have a full factual record. Because it's not enough for me to come in here and just say, Judge, we don't like this indictment. We think it's defective. We have to develop a factual record, which is why we filed the motion for the bill of particulars at arraignment and why all of this litigation has occurred since then. And Your Honor, again, The reason that the Commonwealth hadn't done this, the reason that the Commonwealth waited until the eve of this hearing is because the Commonwealth understands that in order to keep this aggravator, that it admits that the courts cannot kill death on this unless if the aggravator is present. The reason that the Commonwealth won't do it is because it is aware of the legislative history of the enactment of this new aggravator from last year, and that it requires the intentional killing, not the conduct, the intentional killing of a child under 12. And it knows that it has alleged both in the indictment, in the discovery, and now in the faulty reported bill of particulars that it filed last night, that the only allegation is failure to seek medical treatment. At some point, Your Honor, the court, at some point, we're going to ask the court to let us actually litigate this case and to enforce this orders and to make the Commonwealth play by the rules. And this has gone on for 6 months now, and we're asking the court to put a stop to it, please. It needs to stop.
Well, I think first things first. And first is, I think the Commonwealth has to respond to the bill of particulars because the court's going to enter an order granting the bill of particulars. The court thinks that, the arguments about dismissing the indictment or striking the death penalty are a little bit premature at this point.
Yes.
Ms. Fugit, you filed a response to number 2 to the defendant's motion for a bill of particulars. Is that, or is the Commonwealth, you're going to stand on that response? The court's going to give you, how much time do you need to respond to items 1, 3, and 4 of the bill of particulars?
30 days, Your Honor.
Okay. Ms. Girdley, draw up an order. Commonwealth will respond to defendant's motion for bill of particulars and just those as set out in the defendant's motion for bill of particulars that looks like it was served August 23rd, 2023. And after they respond to the bill of particulars, defense can raise any issues it may have with the sufficiency of the response or whatever the defense wants to do at that time. But the court thinks first thing we've
We'll
got to
talk
do
about this when it's
is
over.
grant the defendant's motion for bill of particulars. I believe the Commonwealth is correct that there was no order for a response for a bill of particulars. There was no requirement for a response to the bill of particulars until the court entered the order. We're hearing the argument on that today, and today the court's granting that motion for bill of particulars. So Commonwealth will have 30 days to respond to the defense bill of particulars. We'll get an order out today. And as far as the motion to dismiss or strike the death penalty, they'll be denied for the time being. Right now, court thinks they're premature. Is there anything else that we need to take up?
If we could get a pre-trial date, potentially in June.
Court or plaintiffs?
For it to remain on the court docket.
Yes.
Okay, different points.
Yeah.
For trials, different things. So I don't mind doing this or in June.
A pretrial date is in Bell Circuit Court. It's basically a status conference. It's the way we treat them here. What's a good pretrial date? Yes. June 17th at 9.
I do. It would be one of the 3 days. I'm in trial the 17th through the 19th, Your Honor.
That's all right. We've got other days.
And then my only other unavailability is the 4th at 1 o'clock. We have a 15 codependent syndicate.
Okay.
thing.
Okay. Is that a criminal week or a civil week? Okay. Is June 5th okay?
It is. Can I be a little bit of a diva more than I have been already? Are we able to do things a little later in the morning or in the afternoon? The reason I ask is I live in Cynthiana, so it's about 3 hours.
Yes, sir.
I get to stay in the Econo Lodge when I drive.
We can accommodate that.
Thank you.
Mr. Colson, do we want to do it at 1:30? How about 1:30?
That'd be great. Thank you.
June 5th at 1:30? Okay, pretrial conference June 5th at 1:30. The Commonwealth's going to order, the court's going to order the Commonwealth to respond to all 4 items. Ms. Fugit, the court's not going to, I know you filed a response to number 2. The court's not going to limit you to what you filed. If you want to supplement the response to number 2, you can do that. But 30 days, the court wants a response to number 1, 2, 3, and 4 as defense is requested in its motion. Anything else?
No, yeah, that's right.
Thank you all. Court's adjourned.
Thanks.
Thank you.
Okay, you all, just a second. So, what I got today from that, and if y'all didn't get to watch it, I'm sorry. I was trying every way in the world to be able to get it on my laptop, and last second, I just did it the way I did it because I wanted y'all to be able to see it. Hey, remain calm. They asked the Commonwealth, Lisa Fugit, to file a response to 4 of the motions that was put forth in January. The only response that she filed was to number 2, which was to strike the death penalty. Now, what I did like is that the judge said that he wanted the bill of particulars on that from the defense. She did say that he hadn't put the entirety in his motion in January. So that does make me wonder if maybe I think personally there where what he is talking about is, or she's talking about, is no male DNA. Sorry, you all, I haven't even had my coffee yet, but so they've got 30 days to respond to the other 3. I really don't know why she didn't respond to all of them, y'all. But what got me is exactly what we were saying. If they would have struck the death penalty, it would have brought it down to a Class D felony of like failure to help this kid when she couldn't breathe, and failure to report. That can't happen in this case. Right now, she is the only person that legit is being took to court for this. Nobody else has been arrested. What do y'all think? I'm glad, though, that they are going to have to show a bill of particulars, which explains all the motions. I'm glad about that. Hey, that girl. Yes. Yeah. I agree with that, Michelle. I think she either needs to talk and tell what happened, or she needs to face the consequences by herself. If you're going to take the heat, take every bit of it. No, nobody else has been arrested. They haven't gave out a suspect list. When this case first started, it was said that there was a possibility of up to 6 males. Like 4 of them has been arrested on non-related charges, but none of them have been arrested on this. Then back in January, the defense made a motion, and in his motion, he stated that the DNA test came back with 0 female DNA, which I kind of find that impossible. But it was later said, and this is just allegations because I'm no lawyer and I'm no judge, but that the only our kit that had came back was for female only. So she does need to name some names. Hey, Kim. If anybody wants to come up and talk about this, I'll drop a link. Or Maincom might want to come up. This is sad, you all. July will be a year, and it kind of feels like we're just getting a delay every single time. Yeah, there has to be. I mean, Mills lived in that home for one thing, Michelle. It would be impossible, in my opinion, which I am going to show this to somebody that deals with the courts quite a bit so that maybe it can be broke down to me. But that's how I interpreted it. Last time the defense struck or tried to strike the motion, put forth a motion to dismiss, can't function this early, a motion to dismiss the death penalty. And the judge said there's no merit for that. He's going to need a bill of particulars. Okay, that's okay, Rebecca. I mean, I was hoping that the Commonwealth would address the DNA today at least, but at least we're going to get a bill of particulars. Now, that should give the detail on why the defense and why the Commonwealth believes certain motions should go in. But again, this is, the Commonwealth was trying to say that they normally don't have to respond. I've not heard of that before. But she only responded to the second motion, which was the death penalty being struck. So I'm wondering why she didn't respond to everything else, and I'm wondering if she will, because he didn't tell her that her time limit was over. She's got 30 days, and he wants 1, 2, 3, and 4 responded to. This case is so sad. It breaks my heart. It's one of them that I have to walk away from and come back, because emotionally it will rip you apart. Michelle, if you don't care, we have got a Facebook group called Be Elena's Voice. In that group, what we do is honor Elena. It's not really somewhere that we put screenshots up and throw allegations, this and done it, that and done it. No, it's not about all that. We do try to keep up with the court over there, but this is about honoring her. This group is. And in July, we'll be having another event to mark the 1 year that this baby has been in the arms of the Lord. I want to be able to bring awareness to child abuse and neglect. I want to get booths out there in July. That way, rehabs, just anybody that has a resource that helps people that maybe they need to get off drugs, maybe they need help with housing, maybe they need help with anger management, whatever it might be. I want to have the resources there that they can reach out if they need it. Because that's how we make a difference, you all. Just a second. To simply just get on here and cover this baby's case, and then when a verdict is reached, not mention her no more, in my opinion, would be an injustice. I want to do something that's going to make a difference. There is also a petition that Haley Cheyenne has put up. I'm thinking it's got 30-some thousand signatures on it. It's for harsher punishment for child abusers. She's trying to get the Elena Law Act, the Elena Law passed. And if you all don't care, that is in the group. Yeah, and please answer the questions to get in the group and agree to the rules. It's not against anybody personally, but if all 3 questions are not asked and the rules are not agreed with to, you won't get in the group. I denied my sister 3 times, simply because, not because I didn't know her, but because the rules are there for a reason. And I'm not going to make a difference in my family and anybody else's. If my family don't answer the questions and they don't agree to the rules, they don't get in the group. It's as plain as that. Thank you, Michelle. Michelle dropped the petition in the chat. I asked you to read it. I think once people do read it, they will want to sign it. But in my opinion, this is a law that needs passed. Too many people are able to abuse kids, get a slap on the hand, and then get out. If we don't protect our kids, who's going to? I think that child abusers should be punished to the max. It's my opinion. I don't think they should be able to get out and get more kids and abuse those kids as well. Class D felony is somewhere between 5 and 10 years. 9 times out of 10, they serve 4 and get out. So a change has to be made. I know that I haven't talked much about Elena. I did have a event for her birthday, which declared February the 20th by the mayor, Elena Hembree Day. It was a beautiful event. It was. I was very moved. As some of you already saw it, but the town of Middlesboro before the event let their sirens off, kind of as a moment of silence for Elena to kick off the event. And it's one thing to watch it back on the video, but it was a whole nother thing to be standing in this town where something so horrible happened to this kid and hear nothing but sirens all the way around us, saying we stand with Elena. It was very moving. It was overwhelmingly awesome, to be honest with you. To be there in person was unreal. And I'm honored to have been a part of that. Yes, we need to toughen the laws, Kim. If we don't, I mean, we see it all the time. These people are horrible. Look what they're doing to our kids. And that's a very true statement. But we've got to do something to make a difference. We got to do something to change the laws. Because if we don't, they don't fear going to jail. These people have 9 times out of 10 done time for something mundane before. Probably did a longer time than they get for child abuse or selling drugs. Yes, we do see it too much, Kim. It's heartbreaking. It is. Just yesterday, I opened up my phone and on Facebook, I saw just 2 counties over where a couple had been arrested for trying to sell a set of twins for $5,000. It's heartbreaking. When you can try to sell your kids for less than a used car amount. They put in the protective custody now in jail. They don't fear the other inmates now either. That's true. That's true. When somebody harms a kid, 9 times out of 10, they go into protective custody. They don't need protected. That kid had to go through torment. They need to be put in there with population. They need to be a little scared when they lay down. That's my opinion. But the court from Eric Lawson this morning is at the beginning of this video. Go back and watch it. I was a little distracted trying to get it set up, and I'm sorry that I didn't catch every single bit of it, but it was close to the beginning when I started streaming it on here. By June, I'll have that fixed to where I can share my screen, because when I went in, nothing said you couldn't stream, nothing said you couldn't record, nothing like that. So hopefully in June, we'll be able to share the screen and people can watch it a little more clear. Erica was not in the courtroom this morning. I'm assuming she was on Zoom. I didn't go through the list of people because some people go in there and they put their government name in there. And I don't want to be putting that all up on the screen, y'all. Who was in there this morning is none of my business. I just want justice for this kid. Now, on the 30th of March, I will be doing a live stream on this channel. I'll be streaming it to the Facebook as well. The purpose of that is for people to share memories of Elena. We've got a lot of people in our community that have written poems. They're all pictures. You know, they've done a lot of good things for her. And that day I want to have a open panel where people can come up. They didn't have to know her to speak about her, because this baby's life has, I know around here, changed a lot of people. My heart breaks. It breaks for this baby when I think about what she went through. I find comfort in knowing that we have a Heavenly Father that never let her be harmed. And that's who she's with. I encourage people to speak about this child. Put her name out there. Because she deserves justice, you all. Everything that we have alleged in the Wells case happened to this kid. Just a minute. But if y'all don't care, keep her name out there. Share this video. It helps keep her name out there. Remains Calm has covered this case. Justin for All had me and Duchess on this panel covering this case, but this case needs coverage. It should be all over YouTube, in my opinion. It's not getting it like other cases do. Probably because the drama isn't as thick. But I am covering this, and I won't stop covering this case until we do get justice. This is in my backyard. This is the least I can do. But if y'all didn't get to see the court hearing this morning, just go back to the beginning and watch it. If you don't care, share it out so people can have the most up-to-date information on this case. And remember, it takes zero effort to be a good human being. I love you all. I hope you have a blessed day. See ya.